Hello, good afternoon. Today is Thursday, January the 20th, and we are so excited to welcome you all to our first webinar of the new year. My name is Ashley, and I'm here with attorney Kim Christian. And today, Kim will be talking about the family New Year's resolution. So thank you all for joining us. As always, before we dive in, let's open with some housekeeping items. To help minimize distractions, we have muted your microphones. Some of you have already submitted your questions during registration. Thank you for those. We are also taking your questions live, so please submit them through the Q&A window provided on your Zoom toolbar. We have time reserved at the end for Q&A. We have scheduled this program for a half hour. To help you follow along, we created a few slides, which we are showing on the screen along with our webcams. We are also recording this and we'll email you a link to the recording. Finally, please leave us your feedback in the webinar survey that will appear on your screen when we close out today's webinar. All right, so let's get to know our speaker. Kim Christian has been with Vincent Russo for 15 years and is a dedicated partner assisting clients with their elder law and estate planning needs across Long Island. She's the lead planning attorney in our Lido Beach office, and she also meets with clients in our Garden City location. Her practice areas include elder law, estate and trust planning, special needs planning, and real estate. Kim is an active member of several professional organizations, and she's the previous recipient of the prestigious Super Lawyer Rising Star Award. So, Kim, thank you for being here today. It would not be much of a program without you, so I'm glad you're here. Hi.
Thank you for the wonderful introduction. Happy New Year, everyone. This is our first presentation of the year, so we're excited to have you all aboard. What we'll cover today: implementing your estate plan, the importance of crucial conversations with your family members. Okay, so let's get started. The New Year's resolution, we all talk about them every year. A New Year's resolution is a tradition most common in the Western world, but also found in the Eastern world, in which a person resolves to continue good practices, change an undesired trait or behavior, accomplish a personal goal, or otherwise improve their life at the start of a new year. So we did a little research and we came up with the top 5 most common New Year's resolutions. Some of yours may be on this list, some of yours may be different, there's differing lists, but we pulled some of them, like number 1, more exercise. Number 2, lose weight. Number 3, save money or more money or spend less money. Number 4, spend more time with family and friends. Number 5, perhaps look for a new job or pursue a career. So where does your estate plan fit into these goals? And that's where we come to the family resolution. Let's make a resolution to get our estate planning done, and we'll call it the family resolution. What does estate planning have to do with the family resolution? Well, estate planning encompasses planning for yourself and your family, including healthcare issues and financial matters. It's not always easy to be open, honest, and truthful with communication. And communication can make a significant difference when creating your estate plan. The family resolution can help build stronger relationships among your family members. So let's get to it. We start with something called crucial conversations, right? You want to be open to having a crucial conversation. A crucial conversation is a discussion between 2 or more people where the stakes are high, opinions vary, and emotions run strong. And when it comes to estates and estate planning, I've seen too many families destroyed because of lack of communication. People avoid the difficult conversations, or they go off track because they don't feel safe and supported. So I've seen families struggle over how to leave their assets and to whom, and families fight over how things are done. So I'm going to go through some examples of why a crucial conversation may be helpful when you implement your estate plan. Let's start with something called advance directives. Advance directives in your estate planning are documents that you do in advance of any sort of decline in cognitive ability or any sort of incapacitation. So for example, I might do a power of attorney so that if my cognitive abilities declined and I needed or wanted someone to make financial decisions for me, I have it legally down in writing. Another example is a healthcare proxy. If I can't make my own healthcare decisions, who's going to make them for me? Another example is a living will. And this absolutely boils down to a crucial conversation. It's about end of life decision making. In the event I'm in a permanent persistent vegetative state, 2 doctors agree there's no chance of recovery. But for these extraordinary means, do I want to be kept alive? Or at that point, would I like to be let go peacefully? Or perhaps, how do I want to be buried? What are my burial wishes? Do I want to be cremated? Things of that nature. So let me talk about the living will for a second. Why would you want to have a crucial conversation? Well, if I designate, for example, my daughter as my healthcare proxy, I most certainly would want to convey my thoughts and feelings and desires when it comes to end of life decision making. And it matters for multiple reasons. It matters, one, because she will be making that decision for me one day, perhaps if I'm ever in that situation. And I would want her to know what I want, and I would want it to take the burden off of her, that it was my decision, not hers. And number two, I would want it to be legally valid so that there was ever a challenge, then she had something to rely on. But let's be honest, when we're talking about end of life decision making, the stakes are high, the opinions certainly can vary, and emotions run strong. So you just want to make sure you have that conversation so anybody who's making those decisions for you understands what you would like. And it doesn't have to be about end of life decision. It could be about the smallest decision all the way to the biggest decision. Another example that we see is how a person wants to leave their assets way in the future when they pass away. So I'll give an example. We had a crucial conversation recently that consisted of a mother and a father and 2 children. And one of the children lived in the home with the mother and father and had lived with them over 30 years and continued to live with them. And the mother and the father were very concerned that after they passed away, would the son who lived in the house have to move out immediately? Would he need to stay there for the rest of his life? Could we give him a couple of years to stay and get on his feet and leave? And how would their daughter feel about their son having that right? And they were very concerned, and they said, how are we going to come to a fair and equitable resolution? And that's when you know you should have a crucial conversation. So we talked about it, and we actually ultimately involved the children in the discussion. And I had this come up twice recently, and they both resolved in 2 different ways. So in our first family, when the parents raised the issue, the son who lived in the house said, oh, that's okay. After you pass away, I was actually not planning to stay here. So if you could give me a couple of months just to pack my things up, I'm comfortable with selling the house and splitting it with my other sibling, right? But it took a crucial conversation to get that out and open on the table. And sometimes, you're pleasantly surprised with some of the answers. In another case, which had the similar facts, right? They talked about it and they said, well, you know what? We have other assets that we can leave to our daughter. So maybe we get an appraisal and we find out the value of the house and we leave it to our son who's living there. And then we take another asset that we have of equivalent value and leave it to our daughter. So there are different ways. I'm not saying these are the only ways, but there are different ways to determine a resolution. And the best way to do it is to often have a conversation. So on the next slide, we'll talk about how to have those conversations. So we have some tips when having a crucial conversation. You want to start with a positive intent. You want to share the facts. You want to ask for others' viewpoints, make it safe, and you want to agree to a mutual purpose. So let's start with a positive intent, because where you come from often dictates where you get to. If we approach the conversation with the wrong emotions and mindset, it will likely end poorly. So start with positive intent, goodwill for all parties involved. Share the facts. Don't get hooked on emotion, because it's very easy to do that. Crucial conversations are highly charged emotionally, so we have to be aware of when someone is feeling that way. So share the facts, tell the story, explain things, right? Okay, ask for other viewpoints, make it safe. We need to make a person feel safe. The safer they feel, the more likely they'll open up. Fear can lead to all kinds of things like avoidance, withdrawing, shutting down. So we want to create an environment where everybody can feel safe to discuss their feelings and options. And then, of course, you want to agree to a mutual purpose. So if you have a goal in mind, for example, the one I gave before, we want to express our wishes when it comes to who is going to make financial decisions for us. We want to make sure legally in writing we have who's going to make our healthcare decisions for us. We want to make sure our estate is left in the most equitable way possible. Those are all examples of times where you would have a crucial conversation. If you can all identify the mutual purpose of the conversation, then oftentimes it leads you to a resolution, and a positive one at that. I think it's really important to understand that you can have crucial conversations with your family by yourself, or you can ask a professional to get involved. As I mentioned earlier, many of our clients have the crucial conversations with us, and we can help guide from a legal standpoint what the questions and perhaps maybe some of the possibilities for solutions are. We can also guide the conversation in presenting the law and the facts and keeping everybody on track so that they can achieve that mutual purpose. So, getting to the foundation of your estate plan. There are so many crucial conversations that can be had. But what you want to do for your New Year's resolution is make sure at the very least you have the foundation of your estate plan, whether it be to review what you have existing or whether to actually do it. Get your estate planning in order. This will better my situation. So it's the last will and testament and a trust. And of course, that is what is going to dictate how you leave your assets when you're no longer with us. Your durable power of attorney, which is a document that designates an individual to make financial decision-making for you if you need them to. Your healthcare proxy, which allows someone to make healthcare decisions for you. Your living will, which is about end-of-life decision-making. A HIPAA authorization to make sure your healthcare proxy can speak to your medical professionals, access your medical records, so they're not making any sort of decisions in a vacuum. And sometimes people like to complete what's called a burial designation form. Talk about a crucial conversation. There is a New York State public health law that allows you to designate what your burial wishes are. So for example, do I want to be cremated? Do I want to be buried in a certain place? Do I want to have a wake? All different questions that may lend itself to meeting a crucial conversation. So I encourage you to set one of your New Year's resolutions as getting the foundation of your estate planning in place. It's important and it'll give you peace of mind for the new year going forward. So what do I do now? And this is, I think, the most challenging part when it comes to a New Year's resolution, right? I know for myself, those top 5 on the other side, I definitely had a few of them on my list. So what do I need to do now? Well, you want to create a plan. You want to make sure your legal documents are comprehensive and up to date. So whether you have no existing legal documents whatsoever, or you have existing legal documents and you want to update them, make sure that you have a comprehensive plan and get your plan implemented. Make an appointment, have a checkup. I always liken it to the doctor, right? You just want to make sure you check up on things. Go and make sure everything's in order the way you would want it to be. And when you implement that plan, there may be very well a crucial conversation that occurs. So make sure your family resolution is to get your estate planning implemented. All right, so now I'd like to move to questions. I think in a discussion like this, questions often foster dialogue that many of you may be wondering. So go ahead, Ashley.
Yeah, I don't see any questions live through Zoom. We did have one question that came in before, and you'd have to pardon me. I'll have to jump back a slide or two to
Okay.
get to it. But Nancy had asked, and you may have already touched on this, but how does one find an agent for final wishes to be carried out?
Okay, and when we refer to final wishes, we are talking about perhaps burial designation or cremation, etc. Is that accurate?
I would that's how I would read it. Sure.
Okay,
Yep.
fantastic. So thank you for submitting that question. And there is a legal document that is now out there issued by the New York State Public Health Law 4201. And it's called an appointment of agent for disposition of remains. And what it allows you to do is actually nominate a person or persons in a successive order who will carry out what your burial designation wishes are. So for example, it'll say, I, Kim Christian, appoint my daughter, Chloe Christian, to carry out the following instructions. And then it goes on to say, what are your specific instructions? And many of my clients really get detailed. They say, I'd like to be buried. They say where they want to be buried. They say what kind of wake they want to have. I've even had people talk about what kind of clothes and jewelry they want to be buried in. So you can make it as detailed or as simple that you think makes sense for you. And on this document, you also have the ability to say, yes, I've pre-planned my funeral, or no, I have not. And you have the ability to put the information regarding the pre-plan so that a person knows exactly where to go if they in fact did pre-plan. So that is a very helpful document.
Okay. And can we got a question live. The question is there a limit on the number of primary and or contingent beneficiaries on IRAs? And that's from Herb.
Hi, Herb. Yeah, that's a really good question. So, I mean, technically, there is no limit on how many primary or contingent beneficiaries you can have on an IRA. So, for example, if I had 6 children and I wanted to leave all 6 of them in equal shares, I could actually name all 6 of them as primary beneficiaries on my beneficiary designation form. Now, there's always the legal answer, and then, there's sometimes the real answer. And sometimes a financial institution may say, no, we don't allow for more than X, Y, or Z. So I would say if you do find yourself in a position where there is pushback, speak to your attorney or speak, to a supervisor and see if they are willing to expand that. Is a will, I got another question here, and Ashley, I don't mean to step on your toes, I'm just gonna read it.
Go for it.
Is a will essential if there's only one child to inherit from both parents? And I would say, Hope, I love this question because I get questions a lot. Why do I need a will? And in your example, why do I need a will if one child needs to inherit? And I'll share with everybody that wills have different facets to them. So for example, if we're both leaving it to one child, we say, okay, I leave everything to my daughter, Chloe, right? But what we didn't mention is what happens after that. So for example, you know, in the event, God forbid, Chloe or your child predeceased you, where would it go then? Would it go to your child's grandchildren if they had children, or your grandchildren if your child had children? Would it go to a charity? Would it go to a close friend? So you want to plan for contingencies. In many of our wills, we say, well, I'll give it to my child outright. But if in the future my child becomes disabled and getting money outright would hurt her, I also want to make sure there's a supplemental needs trust in there just in case. Or if my daughter is let's use the word susceptible to outside influences, perhaps you're concerned about a future divorce and you want to protect her from that, you can also put contingency provisions in there. So I would say, yes, the will is certainly essential if you have one child that's going to inherit from both parents. Okay, so Maria said, I'd like an idea on the costs. I don't have any, so where do I start? Excellent question. Okay, so I'm going to go over sort of a general overview what the costs for our law firm are. And essentially we start with our planning meeting. Our planning meeting is typically an hour-and-a-half meeting. That meeting is $600. During that meeting, we will go over from A to Z what your goals are. We will have those crucial conversations. We will identify what plan you need and what legal documents we recommend. And at the end of the meeting, we will certainly give you an outline in black and white what those costs are, so you can make an educated decision as to how you want to go forward. So it's hard for me to give hard costs now because I'm not sure what you would need. But we are happy to have a brief conversation with you. We could talk about generally what you think you might need, and I'll certainly give you a range on that. Kurt, if beneficiaries are listed on your bank accounts and IRAs are your children 18 and 20 years old, what do you suggest? Should there also be a trust? How do you prevent the teen from spending all the monies at once? Great question. And that actually goes back almost to one of the other questions. Does my only child, should I have a will, right? And the answer is, yes, you should have your planning documents. But more specifically, Kurt, to answer your question, one of the possibilities would be to have a trust, because there are retirement benefit trusts that allow us to leave our IRAs to our children, where they still would get the same tax treatment from the IRA, but it would protect them from, for example, cashing out the entire IRA all at once, spending the IRAs all at once, things of that nature. So you can do certainly a trust like that. Or when it comes to your bank accounts, or perhaps a savings or a brokerage account, you can do a regular trust and make sure that you either stagger the ages as to when payouts can occur, or you set a certain amount, for example, every year that the child has, so that they don't spend it all at once. But I would say, Kurt, your question is right on. So many of our clients want to make sure their kids are not punished, but protected, so that in the future they have that nest egg and they don't inadvertently spend it all at once. So the answer to your question, of course, is a case-by-case basis, but the likelihood is we would establish trust.
Right. Kim, I'm going to interject here. We had a question come over the chat
Oh,
from an E. Smith. He is over 75. He has a revocable S&T for a disabled adult child, and he worries that he needs an irrevocable trust.
okay. All right. So if you are worried, and that's a important word there, right? Because that it's important to you, and I agree with you. It's really important to make sure you have the right special needs trust, particularly when it comes to someone who's going to inherit and has a disability. So what I would recommend is that you come in for a planning meeting. We will review that special needs trust. Unfortunately, without seeing it empirically, I cannot comment under as to whether it's the correct trust. But once we read the trust, we will be able to identify whether it is the right kind of trust. So to ease your mind, it may be revocable during your lifetime and ultimately irrevocable when you're not here anymore. So I wouldn't, be overly worried, but I would say, come in for a planning meeting, double check, and we will make sure that you certainly have the right trust. The stakes, we talked about crucial conversations. Talk about these stakes being high, right? We want to protect our child. So I recommend that you come in.
All righty. Kim, I'm going to take the reins over here and go ahead and wrap up with our final slide. I guess the biggest question of all, what makes the Russo Law Group different? Well, it's our partners and associates. They can use their extensive experience and knowledge to handle crisis situations and provide solutions to your immediate problems, or maybe even better yet, plan for issues that may come up later and help avoid those problems in the future. We truly care about our clients. We have over 35 years of experience with state, elder law, and special needs planning. We have 3 convenient office locations. We are available to meet virtually and have the flexibility to make home visits and arrange for out-of-office document signings when necessary. So we have a very robust trust and estate administration department as well. So I would say, please put our experience to the test. Give us a call right after this webinar if you have any questions about what we've covered today. We, of course, appreciate all of you for joining us, and a friendly reminder to please complete the webinar survey that will pop up on your screen when we close out. So Kim, thank you for your presentation. It was great as always.
Thank you. And thanks to all of you for joining us. And we're here for you as a resource if you need anything. So make that resolution, have those crucial conversations. I'm happy to be a part of them, and have a really healthy and safe new year. And I want to I see comments coming in where people are saying thank you, and that was great. And I want to thank them for thanking us, because, we really appreciate the feedback. So have a wonderful day.
Beautiful. Bye.